Good morning. My name is Joel Androphy, and I'm with the law firm of Berg and Androphy, and I'd like to spend a few moments with you this morning talking about the Federal False Claims Act and Qui Tam actions. The Federal False Claims Act is a federal statute that permits private individuals a monetary recovery for successfully bringing suits alleging fraud committed against the federal government or certain state governments. Without Qui Tam action, many reports of wrongdoing against the government, state and federal, would go unnoticed. The economic incentives provided by Qui Tam actions promote private enforcement of federal and state legislation. What proof is required? For you to be a whistleblower, what do you need to give to your lawyers to give to the federal or state governments? You have to provide evidence other than what you know. You may know a lot, but you need witness testimony. Other persons that could corroborate the information that you're providing would be very helpful. Also, documents. The government loves to receive documents. They like to see corporate records, emails, correspondence, PowerPoint presentations, any type of documents that you have that are within your care, custody, and control to provide for the government to assist them in prosecuting these types of cases, and expert testimony. Your lawyers may want to employ experts to help assist and teach the government if these areas involve very sophisticated types of transactions. Public disclosure bar. Like any type of lawsuit, there may be bars to recovery. One of the significant bars in Qui Tam actions is the public disclosure bar. It is a jurisdictional bar that bars any false claims action that is based upon allegations that have already been publicly disclosed. Well, what does the public disclosure mean? Public disclosures are limited to the allegations or transactions of fraud made in a criminal, civil, or administrative hearing, in a congressional administrative or a general office accounting report, or from the news media, Wall Street Journal, New York Times, even a local paper. Even if there is public disclosure, does that mean that you can't report it and get a recovery? The answer is no. If you are an original source, you can overcome the public disclosure bar. To be an original source, you must be, prior to the public disclosure, you voluntarily disclose to the government the information on which the allegations or transactions in the claim are based, or you have knowledge that is independent and materially adds to the publicly disclosed allegations or transactions. And either of these matters, if you could provide and you can satisfy either of these conditions, you must also voluntarily provide the information to the government before you file the action under the false claims statute. Government intervention. When you report a case, the government can decide to intervene and proceed with the case, or not to intervene and you and your lawyer proceed without the government. During the seal period, when you file your lawsuit, it's under seal. The defendants don't see it, the public doesn't see it. The government investigates the case and decides whether they want to intervene and join the case or decide not to intervene. The consequences of intervention. If the government intervenes, they take the lead on prosecuting the case, and you, the whistleblower, and your lawyer proceed and assist the government in reviewing documents, keeping up with the transactions in the case. You cannot interfere, obviously, with what the government's doing, but you generally need to assist the government. The consequences of non-intervention. If the government decides we don't want to intervene, it doesn't mean the case doesn't have merit. The government perhaps could be busy, they may have other matters. A lot of the offices around the country are not well stacked with lawyers. Therefore, they depend on whistleblowers and their attorneys to process these cases. Then you bear the burden of litigating it. The government can jump back in if they want at a later point in time. But if you decide at some point in time to settle the case, you still need the approval of the federal government. And finally, the whistleblower must have a lawyer. He cannot proceed pro se without the government's assistance. Relator recovery. If the government intervenes, the whistleblower can get anywhere between 15 and 25%. There are some exceptions that could lower the percentage. And if the government does not intervene, the whistleblower gets a higher percentage, anywhere between 25 and 30%. In addition to reporting the crimes, the whistleblower has some additional protections. If you're the whistleblower and you tell your company ahead of time to fix the problem, and a lot of whistleblowers do this, before they visit lawyers, they want to fix the problem with the company. They want to keep their jobs. So they tell the company about the wrongdoing. If the company retaliates against them, if they say to the whistleblower, oh, thank you for the information, they suspend the whistleblower, demote him, or fire him, the whistleblower, in addition to the False Claims Act action, has a right of recovery for retaliation. The damages are any and all dollar amounts necessary to make the whistleblower whole. In addition, 2 times the amount of the back pay, so you get the back pay times 2 plus interest, reinstatement to the company with the same seniority status, special damages including your attorney fees and litigation costs. You must pursue this within 3 years of the date that you're retaliated against. There are additional parts of the Qui Tam statute that are available for you to see on the statute or in the book I write on the Federal False Claims Act. Thank you very much.